Ready, Your Honor.
Okay. This is position one from our motions calendar. We've got Mr. Anderson out here. Hello, Mr. Anderson.
Hey, how you doing, y'all?
I'm doing okay. Mr. Anderson is here with his lawyer, Ms. Wood. It's indictment 23 SC 188463. We have Ms. Clark for the state. And Mr. Anderson, Ms. Wood has told me that you are interested in entering a non-negotiated plea. And what that means is that I will hear from Ms. Clark about what she thinks the facts of the case are after we confirm you're waiving your rights to a trial, things like that. She'll make a recommendation. Then Ms. Wood will make a recommendation on your behalf. I'll need to figure out what I think the appropriate sentence is. Because this is happening before your final plea deadline, you'll have the ability to withdraw your plea if you feel that the sentence is too severe. If the sentence I impose is more than what Ms. Wood asked for. So just make a simple example. If Ms. Wood says, I think the sentence should be 1 year, Judge. Ms. Clark says 5 years, and I say 4. 4 is more than 1. And so you'd have the ability to talk with Ms. Wood and say, you know what? I'd rather go to trial. 4 years is too much. I think given this case, I might do all right at trial. And so no, thank you. And it's like it never happened. I don't tell the jury, oh, he actually tried to plead guilty or anything like that. But you're also free to keep going forward with the plea, even if I do sentence you to more than what your lawyer has asked for. Does that make sense?
Yes, it does.
All right. After that final plea deadline, which is not for a few weeks, you can always enter a plea. You just don't get to withdraw it if you don't like your sentence, just like with a trial. If you go to trial and you're found guilty, your sentence is your sentence. You don't get to say no thank you to it. But today, you have the ability to say no thank you. In a moment, Ms. Clark will put you under oath. She's going to ask you a bunch of questions. Please let Ms. Wood or me know if any of those questions don't make sense or are confusing you in any way. Will you do that? Great. Ms. Clark.
Please raise your right hand. Do you swear or affirm that any evidence or testimony that you shall give in the matter currently pending before this court shall be the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
Could you put your hand down? Please state and spell your true, correct, and legal name.
It's Jarius Enrique Anderson, JAIRUS ENRIQUE
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No.
Is there a medication that you normally take that you have not taken or been given today?
No.
How old are you?
38.
What's the highest level of education or the last grade you completed?
Associate's degree.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you've been charged with the following offenses? Count 1, hijacking a motor vehicle. In the second degree, count 2, aggravated assault, and count 3, battery.
Yes.
You understand that you have the right to plead either guilty or not guilty to these charges.
Yes.
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial?
Yes.
Have you had an opportunity to review the indictment in this case?
No, I have.
That's all right.
Oh. Yes, this is my first time seeing it.
So if you need a chance to look through it, you should certainly take that time, Mr. Anderson. The charges in there are the charges that you and Ms. Wood have been talking about. So there's should be nothing new in there. It all involves an incident that allegedly occurred in October of last year when you allegedly tried to take a Kia from Ms. Lewis. That's what these charges are all about. But if you want to take a moment to read it, I don't want to prevent you from doing that.
I read it.
Okay. Any questions about it, or are you comfortable moving forward?
I'm comfortable moving forward.
All right, Ms. Clark.
Have you had enough time to speak with your attorney about all of the charges in the indictment against you, including the facts and circumstances relating to these charges?
Yes.
Are you satisfied with your attorney's services?
Yes.
Attorney Wood, do you waive a formal reading of the indictment?
We do.
Do you waive any defects in the indictment for purposes of this plea?
So waived.
Defendant Anderson, has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
No.
It's 1 to 2 years, 12 months.
We're gonna go over them anyway.
Can't remember what the max is, Judge.
Carjacking in the second degree, I had to look up because I have never done a second degree one. The range is 1 to 10. So you could be sentenced from 1 to 10 years in custody, or it could be probated or whatever, but the range is 1 to 10. Aggravated assault is 1 to 20, and battery is a misdemeanor. So that's 1 day to 12 months.
Okay.
I could sentence you concurrently on those offenses. I could run them consecutively. So the maximum sentence you could receive would be 30 years and 12 months, or as you and I would say, 31 years. The minimum sentence you could get would be probation, where you get out. I don't know how long you've been in, but I'm sure Ms. Wood's going to tell me. Any questions about any of that?
No, I got it. See it right here.
Okay.
One second. Do you understand that your plea today is called a non-negotiated plea,
Yes.
and that the state may recommend a sentence to the court even without your having agreed to it?
Yes.
Have you just, do you understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge?
Yes.
Do you understand that if you enter a non-negotiated plea, you do not have the right to withdraw your plea once the court enters its sentence?
With the exception that because it's before your final plea date, you'll actually be able to do that. Normally, after your final plea date, you can go non-negotiated. Ms. Wood will recommend her number, Ms. Clark will recommend hers, and I'll sentence you, and that's your sentence. But that's not true today. You'll get to hear what my sentence is that I'm giving you, and then you and Ms. Wood can talk about it. And if it's a number higher than what Ms. Wood asked for, then you can think about withdrawing. Now, again, if she says 2 years to serve, and I give you 1 year and 10 months, you may have second thoughts, but you don't get to withdraw your plea because I actually sentenced you at or below what Ms. Wood asked for. Okay?
Let me ask you a question.
What's your question? Question about what he just said.
No.
What's your question? Is it about the case?
No.
Okay. You're on the record.
All right.
You want to ask the question?
No, y'all.
Okay. All right. Questions are fine. Ms. Wood is wise saying, hey, ask me first. If it's about something I just said, it's fine to ask it. But sometimes the question may share something that Ms. Wood would prefer you not share until we know the plea is happening.
All right.
But please don't hesitate to ask anything in particular of Ms. Wood if you've got a question. Are you comfortable moving forward?
Yes, sir.
All right, Ms. Clark.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes.
Are you currently on probation or parole?
No.
Do you understand that if you're on probation or on your own probation, you must follow all the special conditions of your probation?
Yes.
Do you understand that if you fail to follow all the special conditions of your probation, then you will be subject to revocation of that probation for the balance of your sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Are you a United States citizen?
Yes.
Do you understand? Oh, excuse me. Strike that. You understand that by entering a plea of guilty today, you're waiving any and all defenses, including any mental health defenses?
Correct.
You understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to subpoena witnesses on your behalf, the right to testify or offer other evidence, the right to the assistance of counsel, the right to the presumption of innocence, the right not to incriminate yourself, and the right to appeal if convicted of these charges at a trial. Is it your decision to waive these rights, which means not to use them, and enter a guilty plea today?
Yes.
Has anyone forced, threatened, coerced, or promised you anything to get you to enter the guilty plea?
No.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes.
As to indictment number 23 SC 188-463, how do you plead to the charge of hijacking a motor vehicle in the second degree?
Guilty.
How do you plead to the second count, aggravated assault?
Guilty.
And how do you plead to count 3, battery?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
You understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
You understand that if you wish to file a direct appeal, you must do so within 30 days from today's date?
Yes.
You understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes.
Do you understand that for a felony charge, you have only 4 years from today's date to file that petition?
Yes.
Do you understand that for a misdemeanor charge, you only have 12 months from today's date to file that petition?
Yes.
At this time, Your Honor, the state will provide a factual basis for for the felony plea in this case. If this matter would have went to trial, the state would have been able to prove beyond a reasonable doubt that at approximately 1:15 a.m., APD officers responded to the incident location of 1815 Sidney Marcus Boulevard Northeast in Fulton County, otherwise referred to as the dump, concerning a reported carjacking. Upon arrival, officers could hear the victim screaming for help as she struggled with the defendant over a gun. As officers approached, they observed both the victim and the defendant fighting over a gun in the back of the victim's car. Officers separated them and detained them. This interaction between the defendant and the victim were caught on body camera footage. The car was up against a tree in the middle of the parking lot. According to the victim, she was sleeping in the driver's seat of her car when she was awakened by the defendant banging on the driver's side door and demanding to be let into the car. The victim, Ms. Lewis, declined to let him in, at which point the defendant opened the door and attempted to get in the car. The victim and defendant then got into a physical altercation that spilled out of the car into the parking lot. The defendant overpowered the victim, Ms. Lewis, and re-entered the victim's car and attempted to drive away. The victim, however, grabbed onto the defendant and prevented him from leaving. During the struggle, the defendant began driving the victim's car while still trying to fight the victim off. During the fight, the defendant struck a curb, struck a tree, and backed into a second tree. The victim had a gun in the center console and reached for it. Once she had the gun, the defendant began wrestling for the gun, punching her in the face several times. Officers observed swelling to her face and cuts to her lips. The victim also advised that the defendant bit her several times in the back. Officers observed blood to her pink hoodie. EMS arrived on scene and treated the victim for her injuries. They found an estimated 10 bite marks on her back. Speaking with the victim, Your Honor, it was actually about 14 bite marks. Further investigation revealed the defendant had recently fled the scene of 761 Sidney Marcus, where the Quick Trip is, where he had stolen a roll of duct tape. The duct tape was recovered from his person and returned to Quick Trip. When the defendant was being detained, he claimed the victim jumped on him, armed with a pistol, and he fought her off. He claimed he was the victim of an attempted robbery earlier. The defendant said he knocked on the bitch's window and told her to wake up, and that the bitch pulled a pistol on him. He continued to call her a bitch on scene and told officers she was lying. The defendant said he was just trying to tell her it was too dangerous for her to be sleeping out there. The victim, Ms. Lewis, also had her dog in the car, which she advised ran in fright when the attack happened, and that the defendant kicked the dog. Your Honor, the victim, Ms. Monae Lewis, is on the Zoom call. And speaking with Ms. Lewis, she is actually still suffering both physically and mentally since this has happened to her. She indicated that during the attack, the defendant squeezed her windpipe profusely. And she thought that he was trying to kill her. I actually sent, because I thought this was a bond hearing this morning, sent pictures that the victim provided me on last night. She has several cuts, abrasions all over her body. She indicated that the car that she had was pretty much almost a brand new car, and that she'd only had it for, I think, a little over a year. She says right now that she has $9,000 that she still has to pay on that car, even though the defendant, when he drove the car into a tree, wrecked the car. She's experienced a series of, traumas. She feels like she needs, mental health treatment, but does not have the financial means to pay for it. She believes that the defendant, she did not know the defendant, had never seen the man in her life. She believes that he is a threat to society and that he will do this to someone again. The defendant is a total stranger to her, and all of these things that he did to her were extremely dangerous. Today, Your Honor, unless you want me to wait to tell you what the state is asking. Or you want me to
You can tell me when you want. Ms. Lewis is also on the call, so I don't know if she wants to be heard, if you've talked to her, or if a victim advocate has. I don't want to put her on the spot. I'm happy to hear from Ms. Lewis if there are things she wants to add beyond what you've highlighted in terms of how this has affected her and continues to affect her.
She does want to be heard.
Okay. Ms. Lewis, are you there?
Yes, I'm here.
Good morning. It's afternoon now. Good afternoon. Thank you for joining us.
Hi, how are you?
I'm doing okay. If you're comfortable, if you want to tell me more about how this situation has affected you and continues to affect you, you're welcome to do so. You don't have to say anything at all, but this is an opportunity for you to be heard beyond what Ms. Clark has already shared. And I'll let you know, I did receive the photographs. I hope, Ms. Wood, you got the photographs as well that were taken at Grady. So I've reviewed that and seen what you looked like after this happened. That doesn't tell me how you felt. My guess is you were incredibly shaken up and continue to be. But if you want to share things with me, I'm happy to listen.
So for the fracture in my face, that fracture is still there, and it will not, it has not healed yet, and I still get pain from that fracture every single day. I still have nightmares from the situation and everything. I have scars that go across my back and my arm that limit because I used to model full time, and I did a lot of headshots and beauty shots, and because of that, I can no longer work. I can no longer work in the industry because of these scars. It's just sad to me to even. I really want to know why. I want to know why. And then I have pictures of my car from after the incident as well. He was trying to break into my car. You can see where the window is smashed in, where he was trying to smash the window in. And my car is completely totaled out. Like she said, I have almost $10,000 still to pay on my car. That's another debt that's just accumulating because I don't have the finances to pay for that.
So, Ms. Anderson, I've got a couple questions, if I may. One, did you get your dog back? Your dog wasn't lost?
Yes, I have him microchipped, so I did get him back. He is back.
Good. And how about work? Are you able to work? I understand you may not be working in your industry of choice because of the scars that you've talked about, but have you been able to get back to work? And if so, what kind of work are you doing?
Right now, recently I have not been able to get back to work because it's just been I've been scared to take Ubers. It's anybody that remotely looks like him terrifies me.
Okay. And your car doesn't work anymore? I mean, hitting the tree, I understand it damaged it, but it made it undrivable?
Yeah, so the radiator was busted. It was busted in the front and the back. So there was nothing they could do to fix it. The front was completely smashed in, and then the back of the trunk was completely smashed in as well. So my insurance totaled it out.
Okay. And is that a car that you had leased or purchased, or what was
I had bought it through Carvana, so I guess it's considered a lease. I don't really know I don't know the difference, to be honest. And even just looking, like, I'm just looking at me and looking at the size of him. I am 5'4" and 105 pounds. If he wanted to take the car, he could have took the car without having to beat me almost to death.
Okay. Well, Ms. Lewis, I appreciate you being here. I know this is not easy to talk about or hear about, and it's only been a year, so it's still pretty close in time and fresh in mind, clearly. I'm sorry for what you went through. Is there anything more, or do you feel like you've covered what you wanted to cover?
I'm okay.
Okay. Well, I know you're not okay, but I appreciate you sharing what you shared. Thank you. Let me get a little bit more information here. Ms. Jackson, good afternoon. Can you share with me what criminal history information you have, if any, on Mr. Anderson?
Good afternoon, Your Honor. He has 12 cycles. The last arrest was September the 30th, 2022 in Barrow County, Georgia for a DUI. There was no disposition for that arrest. He did receive first offender treatment in 2012 out of Lawrence County, Georgia, for possession of marijuana with the intent to distribute. That case was sealed April the 25th, 2020. He does have misdemeanor convictions. This one in 2019 out of Clayton County for Terroristic Threats Act. This one in 2010 out of Loganville, Georgia, for a DUI. Nothing in addition, Your Honor.
Thank you. Ms. Clark, what is the state's recommendation?
Your Honor, the state's recommendation is for count 1, 10 years confinement, for count 2, 15 years to serve 10 in confinement, and for count 3, battery, 12 months confinement. We're asking that these charges be run concurrent, Your Honor.
All right. Any conditions of probation?
Yes, Your Honor. We're asking that the defendant be required to have a mental health evaluation, to complete treatment if recommended. Also, Your Honor, we're asking for no contact with the victim. And also, Your Honor, an anger management course. And if the defendant is determined to have mental health treatment is a recommendation, we're asking for a HIPAA waiver to confirm, so that probation will be able to confirm the treatment. No drugs unless prescribed, and gainful employment.
All right. Thank you.
Oh, Your Honor, sorry. Also restitution to the victim in an amount of $9,000.
All right. So if we're going to do restitution and we would table that for today, you'd need to get some form of documentation from Ms. Lewis showing that. It sounds like that's something she could get if it was totaled and insurance is paid out. We can make sure it's not a double recovery, or maybe that money's going to the insurance company, who knows, but certainly we can address that. Let's see if we're actually going forward with the plea today. Ms. Wood.
Thank you, Judge. Mr. Anderson, from the time I received this case, has wanted to accept responsibility. We actually tried to plead this on September 13th. Mr. Peoples was the prosecutor at the time. He needed more time to speak with the victim. The incident stems from a period of time in Mr. Anderson's life where he was struggling with the loss of his mother's death and attempting to learn how to process grief. I do want to just give that context to the court. It is his understanding that the victim was involved with some gentlemen who had robbed him earlier in the evening at the MARTA station. He was robbed of his phone, his book bag, and $800. We're not making excuses. I just do want to present that information to the court. He is 38 years old. He's originally from Savannah. He's lived here in Atlanta for 15 years. He has 4 children. He is married. He is an electrician by trade. You heard about his criminal history. He doesn't have a lengthy violent past. Judge, I do believe this is pretty much a one-off. We're asking the court to consider a sentence of 5-1. He's been in custody 381 days on this case. I'm asking for a special condition of a mental health evaluation and a treatment recommended from that evaluation, as well as a stay away from the victim. And I would also request a restitution hearing.
All right. And Mr. Anderson, when you are released, do you go back to Savannah? Are you living in Fulton? Where would home be for you?
McDonough,
And who is in McDonough?
my wife.
All right. I heard you have 4 kids. Are those 4 kids in that household or are they elsewhere?
Nah, I got 3 grown kids and 1 young one.
Okay. And is the young one with your wife in McDonough or somewhere else?
She's with my wife in McDonough.
So you've got a daughter. How old is she?
8.
8. And the other 3 are all adults somewhere else?
They're all adults. They
Okay.
grown.
Are they in Georgia or somewhere else?
They're in Georgia.
Okay. All right. Anything you want to add to this situation?
I just want to apologize to the victim. This never should have happened. Like I said, I was robbed that night. She was with a group of guys who I thought robbed me, and I was just trying to get my belongings back. I just want to offer an apology, a formal apology right now, that this never should have went that far. And I was just trying to get my belongings back.
The apology is important, and I appreciate you doing that. Obviously, it doesn't fix many of the things that Ms. Lewis is working through, but it's important for that to be spoken and for that to be heard. I'm curious, I guess, if you perceived that Ms. Lewis was with these guys who had taken your stuff. I haven't heard anything about, either from what the police observed or from Ms. Lewis's perspective, that it was a 4-on-1 or a 5-on-1, that you were fighting with a bunch of guys and Ms. Lewis. It sounds like you were attacking Ms. Lewis and not someone else. Where did the other guys fit in? If I had a camera and was filming the whole thing, where were they during this?
They was in the vicinity. Like I said, they ran off.
Okay, I didn't hear the ran off part.
No,
okay.
I didn't say that.
Okay.
They ran off.
Were they in the car?
They were in the vicinity.
In the vicinity. Okay. And you thought, we don't know, you thought they were the ones who had robbed you up at the Quick Trip?
No, I was at the MARTA station.
The Lindbergh MARTA station.
Lindbergh
okay, so this is all in the same vicinity.
All this was in the same vicinity.
Okay. All right. And you had taken from you a bunch of money and belongings.
My book bag.
Okay.
My phone.
And then you ended up at the QT.
Ended up at the QT.
And then ultimately in the dump parking lot. Okay. All right. Ms. Clark, did you have something you wanted to add?
Yes, Your Honor. The victim has, of course, is listening. She sent me a text. She said that she does not know who robbed him. She did not have anyone with her that night.
Okay. What I don't want to do is a back and forth. If there's a trial, we'll do that.
Okay.
Ms. Lewis is the victim here. She doesn't need to defend against anything. And it was helpful to hear from Mr. Anderson. That's why I asked. He said these other people were in the vicinity. He's not saying they were in the car with Ms. Lewis and they jumped out when he approached. And it may well be that night, Mr. Anderson, after what you went through, you weren't thinking in the right way, because what you did to Ms. Lewis isn't something that should happen to Ms. Lewis. And you've apologized. And like I said, that's important to hear. I want to make sure, and Ms. Lewis has already said this, that it doesn't happen again to anyone else. You've seen and heard the impact that it had on Ms. Lewis. Here we are a year and a couple weeks later, and it's difficult for her to talk about it. I've seen the pictures of how she looked there in the emergency room right after, and for her to say their scars make sense. And I had no idea that she's someone who, for part of her career, was a model, and now she's saying that's not a possibility. So there's a lasting impact of the decisions you made, and they were ones that terrified her. And I guess we should all be grateful that that gun didn't go off, because you could be dead, she could be dead, you both could be dead. I mean, that's how serious it got. She was scared enough that she was reaching for that, and fortunately the police arrived in time so that it didn't get worse than this already very bad situation. Mr. Anderson, I find that there's a factual basis for your plea. That doesn't mean I'm saying if you go to trial, the jury's going to convict you. But I do think that if the jury heard the kinds of things Ms. Clark has talked about, sees the pictures that they'd get to see, hears testimony from Ms. Lewis, that they could find you guilty. So I'm going to accept your plea. I also find that your plea is knowing and voluntary. Knowing means you've understood the things we've talked about. Do you have any questions about anything we've discussed so far?
No, Your Honor.
Voluntary means no one's forcing you to enter this plea, but you've decided that you want to try out this plea, knowing that you can withdraw it if the sentence I impose is more severe than you're willing to handle right now, and you'd rather have this case go to trial. I'm sentencing you pursuant to the Probation Options Management Act. That means that the portion of your sentence that's on probation, while you're on probation, if you have what we call a technical violation, you miss a meeting, or, and I'm making this up, I'm not suggesting this is your lifestyle, you test positive for marijuana or something like that, you don't have to come back and see me. You and probation will work through whatever the consequences ought to be for that. But if it's more serious, you get arrested for something, or there's any evidence that you have attempted to contact Ms. Lewis in any way, calling her, writing her, anything like that, that will come back to me, and we would deal with the consequences of that. Ms. Lewis has described you as a complete stranger. Would you describe her in the same way? As in, this is not someone you knew prior to the evening of October 23rd?
I didn't know her.
Okay, that's all. I asked that in a weird way, but you didn't know her before that night.
I didn't know her.
That makes the no contact all the easier. It's not someone you've known before, like, oh, I got a set of friends and she's got a set of friends and they're going to overlap. It ought to be real easy for you to never, ever be around her again. You agree?
Yeah, that's correct.
Okay, especially if you're going to be down in McDonough. All right. Mr. Anderson, I am recommending right now, not having heard all the evidence at the trial, but what I've heard and seen today, a sentence of, and I'll break it down in pieces in a minute, of 8 years to serve 3 years with the balance on probation. So count 1 would be 8 to serve 3, count 2 would be 8 to serve 3, and 3 would be serve all 12 months. I've already served those. They'd all run concurrently with each other. You get credit for the time you've been in. The special conditions of probation would be, number 1, most important, no contact with Ms. Lewis. Number 2 would be that you do submit to a mental health evaluation, just so we can make sure if you're working through grief issues or anything else, that a subject matter expert, a doctor or a counselor, can say, you know what, Mr. Anderson, you will be safer and the people around you will be safer if you get some counseling or you take medication, whatever the experts say. If they recommend some form of treatment, that treatment becomes part of your probation. You'll need to take an anger management course. And I'm going to table the question of restitution for 2 reasons. 1, the state needs to prove it up. But 2, I don't even know if you're going to go forward with your plea or not. So I want you and Ms. Wood to talk about it. Clearly, my sentence is more severe than what Ms. Wood asked for. It is 2 years longer, and it's 1 in terms of custody and 1 year more of probation. It's less than what the state asked for. I understand what the state asked for as well. I think this is important for Ms. Lewis to hear. You can hear it as well. I deal with aggravated assaults of all types and natures. And what happened to Ms. Lewis is inexcusable and it's terrifying to her. But you being in jail for 7 years longer than what I imposed isn't going to make her any safer, because I don't think you're ever going to be around her again. It is going to incapacitate you for more years than I think is necessary, and takes you out of a situation you ought to get back to if it's safe and healthy for you to get back to, which would be to be with your family. And 3 years is not a light sentence. I bet you could tell some stories that would be just as traumatic about what the last year has been like at Rice Street. And I'm mindful of that, and that's part of your sentence. But I think that 3 years is sufficient punishment and deterrence, that right now I find that to be a reasonable sentence. 2 more things. 1, that's not necessarily your sentence if you go to trial and you're found guilty. Ms. Wood would be able to say, hey, Judge, you thought that 8-3 was reasonable back in the day, but I could hear more. We would have live testimony from Ms. Lewis. She would have to relive it all. I might learn more about the scope of her injuries, et cetera. So I don't want you to think that you know what would happen if you go to trial and you're found guilty. It would not be a vindictive sentence on my part to sentence you to more after trial is over. Second thing, you and Ms. Wood should talk, because this isn't what you asked for through your lawyer. And so I stand by what I said at the beginning, which is you can withdraw your plea if you think that going to trial would be a better situation for you. And so you know, you will be on our January 10th trial calendar. So trial is not a distant, when would this happen? I would see you again for your final plea, which would be after Thanksgiving, where we would basically repeat this, and I don't know what would have changed by then. And then in early January is the trial count. Just wanted you to have all that information. You two should talk.
Thank you, Judge.
Okay.
She did send me an email.
Okay, great. Then no. Ms. Wood, you are relaying that Mr. Anderson wants to move forward with the plea. What that leaves is restitution, and I will leave that to Ms. Clark and Ms. Wood. It may well be, Ms. Clark, that the documentation that you get from Ms. Lewis is sufficient for Ms. Wood to say, we don't need a hearing based on this. Is $9,000. If we need a hearing, we'll do it. And we may have Mr. Anderson zoom in if he's already been transported to the Department of Corrections. But I'm going to leave that up to you, Ms. Clark, to reach out to Ms. Nelson to schedule the restitution hearing after you've had a chance to review the type of documentation Ms. Lewis has for the damage to her car. Okay. Ms. Lewis, I want to thank you.
Whenever Ms. Clark does get that, if she could forward it to me so I could give it to the accounting team for probation. That way, whenever that does start, the payments will go right over.
I'll be sure to have her get that to you if I impose restitution, but we need to make sure that the paperwork is sufficient and of course, give the defense a chance to contest it if that's what they want to do.
Okay, no problem. Thank you.
Great. Okay. Ms. Lewis, I'm sorry. I was saying one last thing to you. I wanted to thank you for taking time today to be present for what was going to be a bond hearing, but also to share your experience through this. And I wish you the best going forward. This is only another step in your journey of recovery, but your voice was heard. And Mr. Anderson is going to be out of commission for a while now. And more importantly, has a condition for the remainder of his sentence to have no contact with you at all. So I wish you the best as you move forward.
Thank you.
You're very